Thank you, and thank you all for honoring us with your presence today. And it's really good to be invited to back to school here. And I've been listening with amazement and pleasure at all the speakers here. It's a very good, groundbreaking group of people. It's a real pleasure. This morning in the office, when I was preparing to come and thinking about whether I should change into my suit and tie, because I know the studies that show that audiences have no respect for lawyers wearing suits, I faced a choice: do I gain your respect, or do I feel good? And I chose to feel good. So, and I don't really much care if you respect me, although I hope you do. But I'll come back to that, because I'm actually making a point with that. Myself and the others in our firm, and Corey Wanless, who's with us here today, are in court representing Angelica Chalk in Guatemala, whose husband was a community leader speaking out against the human rights abuses of a Canadian mining company, or, to be a little more specific, of a subsidiary of a Canadian mining company. He was not anti-mining, he was anti-mining abuses and for fair treatment for the community. He was a respected leader. On a particular day, he had heard protests happening near the mining company's headquarters in the area. This community is a Mayan indigenous community that is upset about the fact that the mining company, Canadian subsidiary mining company, is taking for a gigantic mine their ancestral lands based on a lease or concession granted by the dictatorial government of Guatemala in the 60s to Inco. So we have on one hand the mining lease, and on the other hand the ancestral Mayan community, of which Adolfo was a spokesperson. On this particular day, he went to try and avoid trouble at the protests. A group of security officers of the mining company grabbed him, dragged him towards their headquarters. And then a fellow named Minor Padilla, and if there's any lawyers for the company or for the PR firms, you make note of what I'm about to say because it's probably defamatory. Minor Padilla grabbed Adolfo and hacked at him with a machete and pulled out a pistol and shot him in the head at close range and killed him in broad daylight with many witnesses standing around. Now, I actually don't think that's defamatory because I happen to think it's true what happened. Before we took the case, we traveled to Guatemala, Corey did, and interviewed a lot of witnesses and videotaped them as well. And that appears to be what happened. That is what we've pleaded in the lawsuit. Minor Padilla, who murdered Adolfo, the plaintiff's husband, with a pistol shot at close range, hung around in the community some more. Eventually, an arrest warrant was put out for him in the Guatemalan legal system, but it wasn't acted on. He continued to hang around in the community. And he's still not arrested. It's been more than a year. We're not sure where he is right now. I don't know if the company did anything with respect to finding him. The lawsuit is based on tort law, plain tort law. We are going to face a foreign non-convenience argument. We, of course, knew that. We carefully structured the lawsuit to, I think, fit within the rules. I usually avoid in court making political or social arguments. I make legal arguments. I think the law, correctly interpreted, the common law of torts and other doctrines, should allow this case to go forward. Although I think all of you We recently received from the lawyers for the mining companies, Hut Bay Minerals, a notice of motion seeking to dismiss the claim based on showing no reasonable cause of action and a form of a convenience argument. Of course, we expected this. We expect this will go to a hearing. We expect whichever side loses will appeal. That will take a long, long time. Let me make bring to your attention 2 points in the notice of motion. First is that under the forum non-convenience argument, the lawyers for Hut Bay says one of the reasons it should not be heard in Canada is that Guatemala has a full and functioning civil judicial system. Now, anybody who knows anything about Guatemala, including Hut Bay, know that's not true. Those binders are about 20 or 30 reports from all kinds of agencies specifically saying that the justice system in Guatemala is essentially non-functioning and is anything but a workable justice system. UN reports, US State Department reports, all manner of human rights agencies. And so we will certainly be addressing this in court, but let me take a step backward. I don't want to get into the legal technicalities of substantive law and procedural law. I mean, those are important. We spend countless thousands of hours, if you will, working out the reality and the strategy of those. But I want to take a step back and ask ourselves this. This is a law school. Some of you are lawyers or will be lawyers. But let me change the camera angle, if you will. How is it that in Canada and Ontario, it can be considered normal and respectable to file in court a document that says Guatemala has a full and functioning civil judicial system? I'm just interested. How can that be considered respectable behavior by our legal profession? I find it interesting. Mining companies play hardball, and I don't mind playing hardball. I had a little fun thinking about the possibility of filing with the Law Society professional complaint about the lawyers for putting this forward. But I put that to you. How is that considered respectful? That such a statement can be put forward in the courts. The other thing they say here is there is no legally recognized duty of care owed by a parent or grandparent company to ensure that the commercial activities carried on by a subsidiary in a foreign country are conducted in a manner designed to protect those people with whom the subsidiary interacts. There is no duty of care owed by a company to the people in a foreign country with whom the subsidiary interacts. Now keep in mind, we're talking here about a subsidiary that's wholly owned and wholly controlled from Toronto. And so what the court is being asked to decide is that a Canadian company which receives its powers from the Canadian legal system has absolutely no duty to care about the people whom its tentacles are interacting with outside the country. Now, Catherine Kuhlman said her talk earlier this afternoon was called On the Wrong Side of History, and I really like that. I don't know what's going to happen in this case on at the motions and appeals. I don't know what's going to happen in the next case. We have other cases going as well. And I admire my friends for the cases they're going for, and I admire the work that our wonderful speakers are undertaking, and what you folks may do if you're the law students. But I ask, do our courts and our judges really want, over time, 5 years from now, 10 years from now, 15 years from now, to be putting forward and be locked into the proposition that the Canadian companies which our system creates has no duty outside of the boundaries to the people that it interacts with. Now, judges care about the role of court and the legitimacy of what of our court's operation. And I kind of hope that our judges will think about where going down this road will leave us a few years down the road, and that in the future they don't go down this road. Courts are human institutions, social institutions, and I hope that we can, in the judicial system, be wise enough to say we don't want to go down that particular road. The last thing I will say, and this gets back to the suit, my lack of a suit this morning, and me not caring. You know, it's been mentioned that one of the problems with these cases is there's not lawyers who take them up. And that's why these folks are, I'm so delighted to be in their company. You know, as you go forward, this is a law school environment. This is Planet Law School. But when you get off out of here into planet Earth, and you think about possibly doing cases like this, there, as I said, are enormous efforts in terms of substantive law, procedural law, the facts, client interaction, which need to be done. And that is an enormous project that requires smarts, it requires commitment, it requires mathematics in terms of how to do spreadsheets so that your law firm survives year after year after year. And you know, I talked about a suit. I don't, when I came to U of T and, you know, talking to my peers, and they drive better cars than me and have bigger houses and have more fancy holidays and eating different restaurants than me. And that's a mathematical necessity if I need to do business, or you for that matter. And so I have to find a way to feel good about myself, even though I don't have those and you're going to have to too. And I do feel good about this. And I have hope for our courts, and we Canadians will find a way to be sensible and human and decent about this. I think the rules of civil procedure are the way we're going to do it.